Good morning. We're going to begin with the arguments in 3RC and Company versus Boynes Trucking System Incorporated, and others. You will have 2 minutes to argue without interruption at the beginning of your arguments. And you each have 15 minutes. Do you wish to reserve any time for rebuttal, Attorney Rivers?
Yes, 4 minutes.
4 minutes?
Yes.
Very well. From the podium, please.
Please, the court. Morning, Your Honors. The Superior Court judge failed to establish or failed to find that there was a joint venture in this matter, even though in her decision, she actually found there's a joint venture. In fact, while the Superior Court says there's no joint venture, it went on to state in its judgment on Joint Appendix, page 62, paragraph 35, it states, Boynes Trucking was entrusted to ensure that the income derived from the fuel operation was used to fully repay the expenses of the joint venture, including the loans 3RC procured from Banco Popular, the Government Development Bank, and the Small Business Administration. Additionally, on page 25, additionally on page 25 of the Joint Appendix, it also states that they breach they found that the Boynes defendants breached the contract between both 3RC and itself, basically stating that they failed to do their part and pay the loan that was procured by 3RC. See, 3RC is the entity, both parties got together. When I say both parties, I mean all of the appellees and all of the appellant got together and decided they're going to do this venture for the procurement of fuel and sell this fuel to the public. Each of these parties had responsibilities, and that responsibility was in the case of 3RC, its responsibility was the startup capital, the development of clientele, and the procurement of the startup equipment and the first 2 loads of fuel. 3RC mortgaged the principal's home. It used its own funds. It borrowed money to a total of initial investment, startup capital of $1.5 million. It was the Boynes defendants, including Jimmy and Joanna Boynes, Boynes Trucking, their
Right,
duty.
you allege that the trial court judge erred by failing to find a joint venture.
Yes, Judge.
What elements of a joint venture did you prove at trial?
Well, I prove that, one, there was an agreement, although it was not an agreement in writing, and you have to take the totality of the circumstances. And in other words, in Yusuf versus Hamed, this court found that a joint venture exists where two or more people carry out as co-owners, carry out as a co-owner of a for-profit business. This was a for-profit business. TRC came up with a capital. TRC went and duty was it to what we call client development. They went out and procure clients to purchase this fuel. And that was demonstrated
Impossible, Attorney Rivers, for all of the businesses to have their own separate roles and to work separately towards the same goal without being a joint venture?
I didn't hear you.
Isn't it possible for each of the businesses to have their separate roles and work towards those goals, but all be separate businesses and not be a joint venture?
It could be possible, but in this case, the business was so intertwined. Remember, the TRC not only paid the money, they also paid for the training for the individuals who were part of Boynes to go to St. Croix to be trained. They paid the insurance on the truck, the truck that was used. They even developed a logo that says TRC Boynes Trucking that was plastered on the vehicle itself. TRC procured the lease. The only thing is TRC did not participate in what we call the day-to-day sales. That was reserved for Boynes Trucking. And the reason is...
Didn't the three companies all have and maintain separate finances throughout the entire relationship?
No. In fact, TRC maintained no financing with respect to this. All of the money collected was collected by Boynes Trucking, and that money was kept by Boynes Trucking and was never shared with 3RC, and that is the prime reason for the breakup. 3RC demanded throughout, we need to have an accounting. Why don't we have an accounting?
But isn't one of the factors to consider whether the parties to the Boynes joint venture shared the profits and the losses?
That is correct, Your Honor.
So did you're arguing against your main argument, which is that there was indeed a joint venture.
There was a joint venture.
So how do you account for the fact that they did not share profits and losses?
Well,
Or
Judge,
did they?
They did.
Well, how did they?
Well, first of all, they paid the expenses on the loan. At first, they started paying the expenses, and then they stopped. So they paid the expenses on the loan.
So when you're referring to they,
I'm talking about Boynes Trucking.
Okay.
Because they're the one who collected the money. And so they paid the expenses. They just never gave any additional money to 3RC themselves, but they paid the loan, the initial loan startup. They did some of that.
well, what about the profits?
And that is the key. And that's why we filed this lawsuit, because in the profits itself, they started to pocket all the profits. In other words, they started to buy houses, take the money for their own personal use.
I'm
and
sorry.
that is the reason why they
Excuse
lost.
me. And was that brought out at trial, that these monies that were used, quote unquote, to buy houses came from the alleged joint venture?
Yes, in fact, at the trial level, and we found it in there, Miss Joanna Boynes says, we took the money that we got in the account, we use it to pay all our bills. We do whatever we want with it because it's our money. Basically, that's what she said. And that's how they treated the money as if it's theirs.
Well, Attorney
No,
Rivers, didn't the parties have a meeting back in February of 2009 and decide that any talk of a joint venture or partnership would be tabled permanently?
Oh, that's correct. They sure did.
And so if the parties agreed that they were not going to enter into a joint venture, why should the court now find that there was a joint venture?
No, but Judge, that's what Boynes said. They didn't, at that point, the money was already in. Mr. Creaky and Triarcy.
It doesn't really matter what was already in, does it, Attorney
But there was no
Rivers?
agreement that there was no joint venture, Your Honor. They state that there's no joint venture.
Well, I'm asking, what I guess we're trying to ask you is you are arguing that the court made a mistake.
Yes.
Because there was indeed a joint venture. So I asked you to point out to me the elements of a joint venture, and you started to do so.
Yes.
But you said, well, the profits were not shared, the losses were.
Yes.
What were the other factors? Was there joint management?
Yes.
And if so, how?
Yes, well, they were joint management of the business itself. Mr. Creaky and Triarcy was involved in what we call client development. He went out, he got large businesses to come and buy fuel from the business. He went out and negotiated agreement with the taxi association. All of these people were coming to buy fuel, both on a retail and a wholesale level.
But is that joint management, or is that a pooling of skills?
Well,
Of
it's
different
both.
skills?
Well, it's both. They did. It's pooling of the skills also is also pooling of the skills. You see, you don't have to. The parties don't have to be involved jointly in every aspect. They could, in fact, assess roles within what each individual would do.
In this case, there was no express agreement. You don't disagree with that?
No, I agree with that. There was no express
So
agreement.
what is
And so-
your argument for a joint venture as to how? How was it created?
well,
What is the name for that joint venture?
or it doesn't need to have a name, but it did in this case. The name of it was Triarcy Boynes Trucking. In fact, that was the logo that was plastered on the truck that delivered the fuel.
Okay, but was it, if it's not in writing, then what is implied in fact?
Yes, it was.
And how?
Well, based on the fact how the operation started out, working. They put a label together on the truck, Triarcy Boynes Trucking. But remember, Triarcy went out, got all this money, paid for the first 2 loads of fuel, paid for the training of the individual, paid for the guy who came from Puerto Rico to inspect the truck, paid for all of those things. Even went out and procured a lease where the property now existed, to the tune of $1.5 million. And when the business started making money, they started paying back the loan for that he took from the bank and from.
This is my concern, Attorney Rivers.
Yes.
There's no written agreement.
There's
we agree on
none.
that.
There's
All right.
no written agreement that specifies
Okay,
or
fine.
says there is.
Good. So once an absence of a written agreement, the court then looks at the evidence presented, correct?
Yes. Yes.
Okay. Didn't the trial court do that?
We want to say they didn't.
They did not?
We want to say that the trial court did. In fact,
Okay, hold on.
if
So
you
they-
would,
hold
if
on,
you were to
hold on, hold on a second, please. So they did have a hearing, an evidentiary hearing?
Yes,
To
we-
make that determination as to whether or not there was a joint venture, correct?
Yes.
And despite your statement that the court stated that it was a joint venture, it could be ascribed as error because there was no finding of fact from the court, was it?
In fact, they did. If
They
you,
found, I'm sorry, the court found that there's a joint venture as a finding of fact?
they concluded that there was no joint venture.
Not my question. Did the court, as a finding of fact,
Well,
find that there's a joint venture, or did they simply, to maybe ascribe as error, say joint venture inadvertently?
well,
Because if it's not as a finding of fact,
I will direct the courts. I will direct the this court's attention to page 62 of the joint appendix, and specifically paragraph 35. And it says here, and this is the court's own decision. It says here, the Boynes Trucking was entrusted to ensure that the income derived from the fuel operation was used to fully repay the expenses of the joint venture. This is the court's own decision.
That's not a finding of fact, though.
Yeah.
That is, did the court specifically say, as a finding of fact, this court finds that it is a joint venture?
No, and that's the problem. While the court concluded that the Boynes defendants, and when I refer to the Boynes, I mean all of them. While the court properly stated that they fail to repay
So let me see
for
if
the
I have-
joint venture, they also find that
Excuse
there
me,
was a
Attorney Rivers, excuse me.
Okay.
So let me ask you. So your argument is the court stated it was a joint venture, but then ruled that there were no joint ventures.
Yes. And additionally, then the court went on to says that they breached their fiduciary duty. And the question
It's
becomes,
two different arguments, though.
it's two different arguments, but
But I'm just trying to make clear in my mind.
yes.
So you're saying that the court, as a finding of fact, found that there was a joint venture. Is that correct?
Judge, Justice, let me be clear. They did not specifically state that they found a joint venture.
All right, you can save, I think your time is up.
Oh, I'm sorry. Oh.
So
Well,
you can save it for rebuttal.
thank you.
Good morning. May it please the court. Nemosha Boykin on behalf of Boynes Trucking System Incorporated, James Boynes and Joanna Boynes. We just have three brief points to make in front of the court this morning. First is that the trial court's decision finding that there was no joint venture should be upheld. Second, that the calculation of damages by the trial court is erroneous. And third, that the trial court was in fact correct in finding that the Boynes principals were not personally liable. Oddly enough, at trial, the court found that there was no joint venture, but there was a contract. However, in its decision, the trial court misstates the terms of that contract. The contract was the agreement that was arrived at by the parties at their 2009 meeting, and that was culminated and memorialized in a signed writing. That agreement was that the gross receipts of the business would be deposited in thirds into each of their respective accounts and applied towards the expenses of the business, excuse me. The important thing here is that 3RC seems to want to divide everything in two. There were three parties at that meeting, including Breeze Shipping. So at most, they would be entitled to a third of the gross receipts to offset their expenses. However, the Boynes parties were responsible for paying all expenses of this business. 3RC at trial put on evidence demonstrating that it spent time getting to know the fuel business, talking with an employee at Hovenza. However, 3RC didn't sufficiently understand the fuel business to understand that what it wanted to do was not reasonable and would not work. The Boynes defendants, having more experience in this industry, did. That's why Mr. Boynes testified that when the parties got together, they saw that there were all these pieces of the puzzle, but they couldn't make them fit into one image. There were three separate puzzles that coincided in certain respects. The responsibility of 3RC was procuring customers. However, those customers didn't pay on time and they didn't pay in advance. When Boynes would get fuel from Hovensa, they would not only have to pay at that time, but they would have to pay before getting the fuel.
Let me ask you, you
Yes.
said that the court found that there was no joint venture.
Correct.
That was as a finding of fact?
Correct.
And where is that located in the transcript that the court stated as a finding of fact, there is no joint venture?
Well, the decision below is a little bit unique in the way that it's written. I can give the court a page cite shortly. However, what the court said is there was no joint venture agreement, and then a few paragraphs later, I believe it might be on page 26 of the appendix, and then a few pages later, it says that there was a contract. So it's a little bit difficult to reconcile those two things, but it's not necessarily inconsistent because there was no joint venture.
But then, okay, then if the court was ambiguous in its findings, then wouldn't we then have to look at the evidence or the facts of the case?
Yes, absolutely, and I
Okay,
urge the court.
now, can you tell me what evidence or factors that made this matter not a joint venture? In other words, what was missing from this matter being a joint venture?
There's a joint purpose missing. If the court will note, the accountant, Ms. Edgecombe, testified that, yes, when people go into business together, they want to make a profit. That's the goal of virtually every legitimate business venture. So, yes, all parties here wanted to enter into a profit. However,
But
that's...
you would concede that point that both parties entered into this for a profit?
Yes.
All right, and that would be part of a joint venture, correct?
Yes, but that's the only evidence of a joint venture in this instance. Otherwise, the role of 3RC was to procure customers. The role of Breeze Shipping was some inter-island transport, and I believe they also obtained a vessel from Greece that they brought to the Virgin Islands. The role of Boynes Trucking was to...
Those are roles,
Correct.
and all of them had the similar purpose, was to obtain profit. Am I correct?
Yes, however, you have to have a joint business purpose. If this court rules that any two individuals who decide that they want to make profit are in fact a partnership or a joint venture, I believe that's a very dangerous precedent to
No,
set in this
because
jurisdiction.
is there a slight difference between a partnership and a joint venture? Though very similar, is there a legal difference
Correct.
between the two?
There's virtually no difference between a partnership and a joint venture.
There is a slight difference, though.
Yes, however, this court has to determine whether there was that coming together and unified purpose of business, and there was not. Simply,
Didn't Boynes and 3RC put together their resources in order to get collateral for the startup loan?
no. 3RC obtained financing, however it obtained it. Boynes obtained their financing, again, over $1 million. Boynes had to finance over $800,000 a month in fuel purchases. This was just a line item in their business portfolio.
Wasn't there a pooling of resources?
I beg your pardon?
Wasn't there a pooling of resources?
I do not see that here.
Well,
You don't see
What-
that as a pooling of resources and management skills?
No. What happened here is that 3RC, for example, said, here's some equipment, we purchased this equipment, you can use it. Boyne said, okay, we're using this equipment, so we'll pay down the debt. However, the income that was received in that business was insufficient to keep making these payments and paying the debt that was incurred both by Boynes and by 3RC.
And isn't that really the only reason why the profits weren't split because there was no profit to split?
Exactly. Yet the trial court somehow made Boynes a guarantor of success for 3RC, which is not substantiated by the record. The only testimony here is that of Ms. Edgecombe below and the financial documents, which, by the way, are not part of the record before this court because contrary to Rule 10 of the Rules of Appellate Procedure, those exhibits were not provided. However, those documents show that the business was not profitable. Boynes was...
So for me to be clear, you agree that they intended to split the profits and the profits would have been split if there had been profits?
I would agree with that statement limited to the modification of receipts, because the only evidence below is that the parties intended that the gross receipts of the business would be used to pay the expenses of the business. There's no evidence as to what is to be done with the profits of the business. However, the record is clear that there were no profits of the business. The record is clear that Boynes were having to borrow from Peter to pay Paul to keep this revolving fuel expense account at Hovenza.
Is the yardstick the fact that there's no profit, or is it that intent to share the profit and losses? Is it not intent, or do you actually have to have a profit?
And that's the problem with this case. 3RC is proceeding on its projections, on its assumption, without understanding the cost and expense and how the fuel business actually operated. That's why there was no joint venture.
But you stated, and correct me if I'm wrong, but you stated that there was an intent to share the profit.
Correct.
That is why there was a request for the receipts. Excuse me, am I correct?
Yeah, that's fine. I can concede that, Your Honor.
Okay.
However, there was still no joint venture. There was
let
no
me-
joint,
If there was no profits, does it matter whether you argue that there was a joint venture or not?
I believe it's important, especially in terms of the precedent that this court will set. And 3RC1, the court affirmed that a joint venture and a partnership are essentially the same business. It provided the elements on how to find that. And in this instance, whatever the court decides is going to give guidance to the business community. Individuals need to know if they have an agreement with somebody, are we helping each other out? Are we forming a joint business? What's happening here? And in this instance, there are actually three businesses involved. And one of those businesses is trying to make another, the Boynes trucking system, a guarantor of its success. And that's not supported by the record and is wholly improper. So yes, regardless.
You also made a point to say that the court made a mistake when it's calculated damages.
Yes, absolutely.
Did you appeal? Did you cross appeal?
No, this argument is just being made
Okay.
in opposition to the appellant's argument.
All right.
Correct. And again, the court will note that the damages that the appellant is seeking are not supported by the record. The financial documents that were admitted at trial were not provided. The only evidence before the court is the actual transcript of the trial. And based on that, appellant's request for damages is not substantiated. The appellant argues that the trial court should have ordered Boynes to provide an accounting. However, what was the purpose of trial? Was it not appellant's duty to prove that at trial, to prove that this is the amount of money we're suing for? These are the profits. This is the income that we believe they have. They didn't present.
One of the arguments that you make as well is that the appeal that's filed in this case was not timely. Do you still maintain that argument today?
If the court agrees with my argument, yes. It's quite a technical argument, but we do believe that if you read the rules strictly according to what they say, particularly in light of the fact that the motion for reconsideration is really just an agreement with, disagreement, with the trial court's decision, yes, we do believe that it was filed untimely. Last, Boynes Trucking would like the court to uphold the finding below that the Boynes principals are not liable. There was no evidence of misuse of the corporate entity. There's no evidence of fraud. There's no evidence of malicious intent. The entity was not an alter ego of the Boynes principals. Therefore, to the extent that, some personal expenses might have been paid from the business, there's nothing wrong with that, and that's not sufficient to rise to the level of misconduct. And as a matter of fact, there was no misconduct. That's not sufficient to rise to that level to show that the corporate veil should have been pierced.
Hey, Boykin, I just want to make sure I understand your timeliness argument. The appellant filed a motion for reconsideration, which I suppose the appellant believes would have told the statute of limitations, but you don't think that's correct. Is that right?
Correct. That,
Your argument, and let me see if I understand that time limits argument correctly. Your argument is that a motion for reconsideration tolls nothing with
No.
regard to an appeal. Is that your argument?
no, Your Honor.
Okay.
My argument is that a true motion for reconsideration would toll the time. However, if the court looks at the substance of the motion for reconsideration that was actually filed, it's just a mere disagreement with the trial court's decision.
Okay.
Then who determines whether it's frivolous or not? Isn't it that the mere filing of that motion tolls the time, or does the judge have to say it's frivolous and then, okay, your jurisdiction is lost? Is that basically your argument? If it's a frivolous motion, you said that if the motion is a true motion or a legal argument, then fine, the time would be told. If not, then if it's frivolous, not according to the court, but opposing to counsel, then this court should find that jurisdiction has expired. Is that basically your argument?
Yes, if it doesn't meet the standards of the rule, there's no manifest injustice, there's no newly discovered evidence, there's no need to correct clear error.
Who determines that?
This court.
Or the trial court?
The trial court could determine that. However, since the rule provides that after 120 days, the movant can actually consider that the motion has been denied or whatever and file the appeal. I mean, due to the automatic functioning of the 120-day time limit, I do believe that it's within the jurisdiction of this court to make that decision. And lastly, I see my time is almost up. I would also like to bring the court's attention to the fact that there was no misconduct. Money was shared. Boynes paid extensive amounts to 3RC, over $850,000. They just want more. They want Boynes Trucking to be a guarantor of their operating cost of their attempt to enter into the fuel business, regardless whether it was successful. And there's absolutely no standard in law that requires that outcome. Unless the panel has any further questions, thank you for your time.
Thank you.
Thank you.
With respect to what the law court found with respect to the findings, the law court found that Creaky and Boynes agreed that the fuel for the operation would be purchased from Hovensa on St. Croix and retail distribution on St. Thomas. And that's found at, and also the trial court also found that 3RC and Boynes Trucking agreed that 3RC responsibility would be for client development and the procurement, and that Boynes Trucking would be responsible for the delivery of such fuel. They also found that Boynes Trucking agreed to pay the debt and service the loan that Creaky had for paying for the start of business. They also agreed, this is what the trial court found. They also found that 3RC purchased the tractor trucks from Canada and from St. John.
What point are you trying to make to us?
Well, Judge, I think one of the questions directed to the appellee was where did you point to what evidence that didn't establish that there was a partnership, a joint venture? And I'm pointing out where the trial court found these. This is the trial court's own finding, but still said that there was no joint venture. And so that's what we're saying was incorrect. But if I could just pivot on another argument that was made. With respect to the fiduciary duty that the trial court found that Boynes Trucking was in breach of the fiduciary duty, the question becomes, who breaches fiduciary duty and to whom was the fiduciary duty owed? And we're arguing that this was the principles of Boynes Trucking, which is Jimmy Boynes and Joanna Boynes. These are the people that breached their fiduciary duty.
What damages did you prove at trial?
That Mr. Creaky invested over $1.5 million of his own money.
Beyond that, what damages, if any, did you prove?
Almost all of the money that was generated from the fuel business was a result of having sold the fuel that was originally purchased. You see, once 3RC paid for the first 2 loads of fuel, then all the expenses, everything that
How did you prove that at trial?
We proved that at trial.
How? Who did you call to prove that?
Both Mr. Creaky and Joanna Boynes and Jimmy Boynes. Basically, what they indicated is that Mr.
Did they provide accounting to the court? Did they provide, what did they provide to the court other than their testimony?
Their testimony, and we showed the checks that was paid to Hovensa for the fuel. The first, because the way the fuel operated is you have to pay for the fuel before you get the first drop of fuel. And so you pay for the first, and then you pay for the second before the first one finished, otherwise you'll be out of fuel. So basically, he made the first 2 payments on for the fuel coming over.
But the fuel funds go to Hovensa except for the transportation costs.
Boynes was responsible for transporting the fuel from St. Croix to St. Thomas. That was the shared responsibility. They transported the fuel because...
Speaking about funds, Attorney Rivers, stay with me, please.
Oh, I'm sorry.
Did not the fuel funds go to Hovensa?
Yes.
Even though Mr. Boynes had to friend them?
No, Mr. Creaky.
Mr. Creaky?
Of 3RC fronted that, yes. The fuel came from Hovensa. And it was...
And so Hovensa had to be paid for the fuel?
Hovensa was paid for the fuel.
So you're saying there was a joint venture. Where would the joint venture get its profits from?
From the sale of fuel. From the sale of the fuel.
Well, but if you have to pay Hovensa $1 for each gallon of gas.
Yes.
And so Mr. Creaky goes to Hovensa and he purchases 10 gallons of gas.
Yes.
Isn't Hovensa going to get those $10?
They get paid.
So I'm asking you, where's your profit coming from? Or the profit of the joint venture you say existed?
Well, remember they purchased the fuel. They brought the fuel to St. Thomas.
Transportation.
Transportation. Boynes Trucking already had a badge that moved fuel.
We're familiar with that.
Okay.
I'm trying to find out how you proved to the trial court what the profits or losses were. You're saying there were profits, but did you prove there were any profits?
Yes, we proved.
And what dollar amount did you prove in profits?
Judge,
Point me to the joint appendix where you say, Judge, this is the measure of damages for this joint venture. This is what we proved.
I can't do that right now, but what we established was that the Boynes
I
defendant...
know what you established.
Yes.
And I'm questioning whether that was enough.
Yeah.
So that's why I'm asking you these questions, to find out what damages you proved before the trial court.
Well, Judge, we proved that they used the money to fund other ventures rather
But you don't know whether it was $10 or $1,000 or $1. Because you didn't prove that at the trial court level, did you? Did you say you thought that the trial court was supposed to figure that one out?
No, Judge. We established through, in fact, we established that the money that they made was a tremendous amount of money, but they used the money for their own personal gains. They purchased homes, they went on motorcycle escapades.
That's your argument. But what was the proof of that?
Well, Joanna Boynes testified that's what she used the money for, and she felt she could do it. She said it was our money and I could do whatever I want with it. She said it on the stand.
Well, didn't the Boynes have several businesses?
In fact, they did.
Okay.
And here's the
And your time
here's the
your
catch.
time is up again, so thank you very much.
Yes.